So let's introduce Mr. Legal Update himself, Gov Hutchinson. Gov is the Assistant General Counsel of the California Association of Realtors. He's been with the Realtor family since I was born, and he manages to That's not funny. That's a compliment, right? Well seasoned. He knows what he's talking about. He manages the legal services program down at CAR. He advises realtors on our legal hotline. He received his bachelor's degree in history from Princeton, never heard of it, as well as his JD from the University of Pennsylvania. He has written articles for our magazine. He's a master instructor in the education division for our association and provides certified classes from the California Department of Real Estate. He regularly speaks to associations like ours, so let's get him up here, Mr.
All right, thank you. Thank you. So you were born in '85, huh?
I was.
All right. Who were you realtors in '85? Who remembers '85? We remember the 2-page purchase contract. We remember no electronic forms. Remember that? No cell phones, no email. Life was simpler. Life was better. Yay. Okay, whatever. Anyway. Actually, it's interesting to talk about that because obviously what I'm here to do is update you on the new stuff. And I talk about new laws and I talk about new forms. And a lot of times, have you noticed, it's sort of bad news for me, and I try to couch it in a way that's not so bad and make it entertaining, but it's still bad. Actually, I've got good news today, a lot of good news. And part of it relates to what we just talked about starting in '85. Ever since I worked at CAR, there have been some laws in the real estate law that I would characterize as just dumb, right? And a lot of us at CAR realize they're dumb. So finally this year, after 30 years, we were given the opportunity in the legal department, make a list of the dumb laws, and we can try to get some of them changed. How do you like that? Well, it actually happened. We got a bill in front of the governor, he signed it, which changed a lot of dumb things. So let me start with that. I mean, it's really good stuff. I mean, obviously the world has changed in the last 30 years, as I just mentioned, but some of the laws haven't caught up. You know what I mean, in the real estate law? I mean, I'll give you an example. Do you know there's a law that says when you take a listing, you must immediately, like in the next 5 seconds, give a hard copy of the listing that your client just signed to them physically. In the old days, this was easy. Remember the carbon copy contracts? You young people have no idea what we're talking about, but yes, there were 4 copies. There was no zip form, so you'd pull out the listing form, your client would sign it, you'd rip out the carbon copy and give it to them. How easy was that? That's not the way the world works anymore, is it? But nevertheless, the law has never changed that you have to give a hard copy of the listing form to your client as soon as they sign it. Well, they finally changed that. The new law says all you got to do is give them any type of copy. It could be electronic as soon as practical. I mean, up until now, right, unless they sign the listing at your office where you have a printer, it's been pretty hard to do it, right? Do you travel around with a printer in your back seat, you know? I bet a lot of you have been taking listings and not giving them a copy right away. Am I right? You want to admit that you're a criminal? Okay, that's all right. I got it. The point is you're not a criminal anymore. Effective January 1st, you're not a criminal anymore. That's an example. Okay, so once again, my first law I'm talking about is we call it the real estate cleanup law. And it cleans up a lot of things like I just said. Let's start with agency. You know, in the agency law, you got that agency form, the agency disclosure form. And you know, you get the listing agent, you give one to your seller, and the selling agent, you give one to the buyer, right? Have you ever heard me say in the 30 years you've known me, the dumbest law in real estate is the law that says the buyer's agent has to also give an agency to the seller, right? There's 3 agencies. Listing agent to seller, that makes sense. Selling agent to buyer, that makes sense. But why would the selling agent give an agency to the seller? Their own agent already gave them the same form. And you're not giving them that form and you're not representing them anyway. So what most of you have adapted to do over the years is you give, when you're the buyer's agent, you give an agency to your buyer and they sign it, and then the seller signs that box, right, at the bottom of that form. But you still got to chase around the listing agent to make sure they do it and send it back. Dumbest law in real estate. Well, guess what? Effective January 1st, no more. No more. Yay. One agency form per client. Yeah. Listing agent gives one to the seller, selling agent gives one to the buyer, and you're done. You don't have to work. We're going to take that box off of the first page of the agency form. You don't need it. I mean, if that's all it was, I'd be happy. I'd be done. You know, if that was the only change they did. But there's more. There's more. Remember your very first day in real estate when you're learning terminology. And remember the terminology they gave you was the seller's agent's the listing agent and the buyer's agent's the selling agent. Remember how that threw you a little bit? It still does, right? I mean, like, why would I call the seller's agent the selling agent? Isn't that the buyer? Yeah, the buyer's agent is the selling agent. So confusing. That's another thing that just got fixed. All of your forms now are, instead of saying listing agent, selling agent, we're going to say seller's agent, buyer's agent. Wonderful stuff here. Wonderful. All the terms in the real estate law. Attorneys like me, we had to painstakingly go through the law, and every time the law referred to the selling agent, we changed it to the buyer's agent. So that's good. Very good. Another thing on agency. So that's the agency disclosure form. There's the issue of dual agency. How many of you have ever sold your own listing? You know, I would say most of you. Thankfully, it is legal in California to do that. Do you know in a lot of places it's not legal? Do you know what happened this year? The entire country of Canada banned dual agency. Don't move to Canada if you want to be a realtor. Because not only can't you sell your own listing, you can't sell any of your company's listings either. Yeah. It's like that in some other states too. That's another reason you contribute money to your political action, because not only to support these candidates, support these propositions, we got to stop the bad laws from getting passed. Every year somebody proposes in the California legislature a law outlawing dual agency. Every year we have to fight it. Every year someone will pass a law that says there should be a sales tax on real estate commissions. Every year we got to pass it. We need your money to contribute to the right people, you know? So remember that. Well, I'm on camera here, I'm sorry. Yeah, I was just kidding there. Okay, right. But like he said before, I was required, no, he took it, I was supposed to remind you, but he did it already, yes on 5 and no on 10. I guess 6 is, I'm told I don't have to talk about 6, but yes on 5, no on 10. To amplify a little bit what he said, remember the portability of property tax means if Prop 5 passes, you can take whatever property tax you're paying on this house and move it anywhere in the state as many times as you want, even if the new house is worth more than the house you got now, in which case you pay a blended lower rate. So Prop 5 is a good thing. There's no more, right now seniors don't want to move because for property tax reasons. That shouldn't be the only reason you don't want to move. Realtors, we want people to move all the time. We want people to move every 2 months. Do you want to sell your house? No, I just moved in. Aren't you bored yet? Move again. Yes. More seriously though, we don't want people to be trapped in their homes just because of the property tax situation. And then of course Prop 10 that you're going to vote against would totally expand rent control. Do you guys have rent control? Probably not, right? So maybe you never will, so in which case it might not affect you directly, but you never know what's going to happen in the future, and you want to support your fellow realtors and fellow property owners in other parts of the state where there is rent control, because this current law sponsored by CR many years ago says even in a city where there is rent control, there are limitations. Rent control does not apply to single-family homes. Rent control does not apply to new construction built after the day the rent control law was passed. And even in San Francisco, if you move, the landlord can raise the rent for the new tenant. If this Prop 10 passes, all that's gone. Cities can have rent control apply to single-family homes, brand new homes, and even if you move out, they can't raise the rent. This would not be good for private property ownership rights, so that's why we're saying. All right, enough sales pitch on that. Okay. Back to the great law. Back to the great law. Okay. One more thing. You know, in the agency confirmation paragraph, paragraph 2 of the purchase contract, have you ever noticed it says, all right, what's the name of the seller's agent, buyer's agent, but then it puts in parentheses brokerage firm. So it says seller's agent, so you think you're going to put somebody's name there, right? But you actually put the name of the company. A little bit confusing. They fixed that too. Starting in December, when you look at your purchase contract in paragraph 2, instead of it's going to say seller's brokerage firm. Whoa. And then under that, it's going to say seller's agent. Whoa. And then under that, it's going to say buyer's brokerage firm, buyer's agent. So you're actually going to put 4 things down. I mean, that's a little more work, I know, but at least it's less confusing. So you're going to put 4 names, but you're also going to put 4 DRE numbers. Well, think about that for a second. You're writing the offer, you're the buyer's agent, so you know your company's name, you know your name, and you know your DRE number, and you're easy to get your broker's DRE number. But now you also have to fill in the seller's part, the seller's agent's part. But you know, it's on the MLS, you can get the DRE number. In other words, I would say don't leave it blank. Some agents, oh, I should leave that blank. But then they have to counter you back. You don't want a counter offer just to fill in the agency. So if I were you as a buyer's agent, you're going to put down the name of the listing, seller's broker's company, and that name, get their DRE numbers either from them or from the MLS, no counter offer. At least it makes more sense. One more thing, back to this dual agency. I asked you how many of you sold your own listing. Okay. You know what the challenge of dual agency is? Here's the challenge. When you're a dual agent, you have a fiduciary duty to both clients, obviously. Fiduciary duty means, among other things, confidentiality. When your client tells you something in confidence, you're supposed to keep it confidential. You're like a priest or a rabbi, or a doctor or a lawyer. You have the same level of confidentiality. On the other hand, when you're an agent of any kind, you owe your client a duty of full disclosure, not just material facts. That's your duty to a customer. Your duty to a client is to disclose not just material facts about the property, but all facts that would materially affect their interest in this transaction. So imagine you're representing the seller and the buyer. And the seller says to you, well, it's listed for $400, but I'll take $375. And your buyer client says, well, I'm offering $350, but I'll go to $390. Do you tell the seller what your buyer just told you and tell the buyer what the seller just told you? No. You know why? Because the Civil Code has always said very clearly you don't have to. Well, that's good. But what about if your seller says to you, you know, my wife just got transferred to Tucson, so we got to move in a week, so we really got to close this in a week. So whatever the buyer wants, I'll do it. Now, your buyer would love to know this, wouldn't they? Your buyer would love to know what the seller's weak bargaining position is. And you have a duty to your buyer to tell them everything materially affecting their interests. But on the other hand, you have a duty to your seller to keep confidential what they just told you. So what takes precedence? Your duty of confidentiality to one of your clients or your duty of full disclosure to your other client? For 30 years, I've been saying to realtors, since we don't really know the answer, my advice to a dual agent is tell both of your clients, don't tell me anything you don't want the other one to know. See what I'm saying? Well, I have good news for you. They just clarified it. They just says in the Civil Code now, it's just been changed to say when you're a dual agent, anything that either one of your clients tells you in confidence about their bargaining position, financial position, or anything else, you can keep confidential. Confidentiality wins. At least you have a clear answer now. I bet all of you were doing confidentiality anyway. My gut feeling of realtors, when you had 2 clients, one told you something in confidence, and the other didn't, you wouldn't tell the other one. Well, up until now, you didn't have any support to do that. You were just going on your gut feeling. Turns out your gut feeling was right. So that's good news. Clarity on your responsibilities as a dual agent. So I like that. More stuff in this law. The more good stuff. You know the transfer disclosure statement? How do you normally deliver that to your buyer? Let me ask you, do you normally email it to the buyer's agent? Do you give them a hard copy? Do you post it? Anybody tell me, the last time you did a TDS, how did you deliver it? Email. Do you know you're all criminals? Do you know the current law says the only way to deliver a TDS is with hand delivering a physical hard copy or mailing in the U.S. mail a hard copy. Like I said, the law hasn't caught up to what people do. So you'll be happy to know you're no longer criminals. The law now says TDSs can be delivered electronically. Whoa. Of course, that law doesn't take effect till January 1st. Am I a criminal for the next 2 months? No. You're not going to get in trouble, so go ahead and keep doing what you were doing. So that's good, right? Deliver electronically. But did you know that when you deliver the TDS to the buyer, they have a right of cancellation, a right of rescission? Do you know even if they've removed all of their contingencies, if you don't give them the TDS early, they can still walk away from the deal? How many days do they have to do that?
3.
3 only if you deliver them a hard copy. Well, since you guys aren't delivering hard copies, and now it's actually legal not to deliver a hard copy, how many days do they get? The answer is 5. So when you email a TDS, the buyer has 5 days once receiving it to cancel the deal. But that leads to another question. What if I email it to the buyer's agent? Is that when the 5 days start, or does it start when the buyer's agent delivers it to their buyer? Good news for you. When you deliver it to the buyer's agent, the clock begins. So you on the seller's side don't have to worry about the buyer's agent delivering it, because the buyer's agent could take forever, and they're extending their buyer's right of cancellation, which is not fair to you. So TDSs can be delivered electronically. Deliver them to the buyer's agent. You don't have to worry about delivering to the buyer. And as soon as the buyer's agent receives it, the buyer is on the clock. So obviously, if you deliver this early in the deal, those 5 days are over even before their 17 days are over, so you don't have to worry about it. The problem is some agents wait till later, or they do their avid later. Seller's agent, the TDS is not complete until you do your visual inspection and your avid and deliver that to the buyer's agent. That's when the 5 days begin. Buyer, listen very carefully, buyer's agent, you don't even have to sign the TDS anymore. The TDS is considered complete when it is signed by the seller and the listing agent and delivered to the buyer's agent. Yes, buyer's agent, you have a duty to your buyer to do a visual inspection, for sure. And you should probably use the avid form to do that. But as far as the buyer's right to cancel, your activities as a buyer's agent are totally irrelevant. You don't sign the TDS is done when you receive it signed by the seller and the listing agent. Question back there? Yeah.
How do you apply when the TDS 1 or 2 or 3 boxes when the check by the seller?
That is a very good question. I'll repeat her question. And it was also addressed by this new law. It's a big problem with the TDS when the seller doesn't fill everything out. And this law makes clear that if you don't fill it out, it's not done, which means the buyer can still walk away. I think a common problem is sellers are filling out the TDS, and they come to a question and they don't know the answer. The question is, has anything in the house ever been built without a permit? And the seller says, how do I know? I didn't buy it new. I don't know if a previous owner did something without a permit that they should have done, so I don't know the answer to that question. I'm just going to skip it. By skipping it, they're violating the law. They're not completing the TDS, and the buyer can still walk away. So you advise your clients, if you don't know the answer, put no, because the questions are all phrased, are you aware? They're not saying, is this true? They're saying, are you aware? If you're not aware, you're not saying yes or no, you're just saying I'm not aware. So please answer every question. Remember, as a realtor, don't help them fill it out. But when they're all done, take a look at it to see if they answered all the questions. When they're filling it out, don't even be in the same room with them. You know why, right? Because if you're in the same room with them and they ever get sued, they're going to say, I didn't mean to say that, my realtor told me to say that. She was sitting right next to me, she said answer like that. This will never happen to you if you're not there when they fill it out. So don't help them fill it out. Don't help. This sounds like she's taking notes. Okay, yes. Don't help them fill it out. Actually, you can help them fill out the first page of the TDS where they check those boxes, right? Does the house have a dishwasher? Does it have a trash compactor? Because sometimes then they just make mistakes. Let's say the seller checks the box and says, I have a trash compactor. Well, you're the seller's agent, you probably say, you don't have a trash compactor. You might want to fix that. By the way, what if the seller says they have a trash compactor? You know they don't. You tell them you might want to change it. They say, I'm not changing it. What do? On your part of the TDS, you write down, my seller's an idiot. He thinks he has a trash compactor. I'm sorry, he doesn't. Yes.
Regarding the rescission period.
Yes.
Can they forego that period?
You mean by contract?
Yeah. So let's say they have a new disclosure comes up, and they have to wait the 5 days. But they close of escrow before that. Can they forego the 5 days?
Yes. Let me really clarify his question. You give the disclosure to the buyer, they got 5 days. But sometimes, unfortunately, the seller has a new disclosure they forgot to give them in the first place, right? By the way, if the buyer or home inspector finds a problem, the seller doesn't have to redo the TDS. If an agent finds a problem, the seller doesn't have to redo the TDS. The only time you have to add to your TDS is if the seller, oops, I forgot something. Oops, I forgot to tell you there was a death on the property. I shot that guy. I don't know how I forgot that, but you know. In other words, so point number one is you don't always have to change. It's rare that you really have to change. But let's say the seller really does 4 days before escrow closes. Oops, there's a very important problem I need to disclose, and you got to disclose. You don't want to get sued. His question is that, but I'm closing in 4 days. Well, just because you give them the new TDS, which gives them a 5-day right of rescission, doesn't mean they have to exercise it. So if you close, you're closed. And once it's closed, it's over. Buyer cannot come back later and say, I want to undo the transaction. No, it's closed, it's closed. So try not to forget things. Try to get it done early. Make sure the seller fills out the first page correctly. Don't help them fill out the second page, but make sure they answer every question. Email it to the buyer's agent early in the deal, and that's when the clock begins. Yes? I'll repeat your question, yeah. No, you're right. Seller has 7 days to deliver stuff. But regardless if they deliver during those 7 days or after those 7 days, from the date the buyer's agent receives it, that's when the 5 days begin. By the way, I was just in San Jose a couple days ago or last week, and they're so crazy there. Well, I should say the market's so crazy there that they get multiple offers, so they want to screen out the offer. So they say, we're not taking any offers if there's any contingencies. I mean, it's that crazy there. So if they don't get a non-contingent offer, they won't even look at it. So the buyer has no contingencies, but buyer still has 5 days to get out of the deal, right, based on the TDS. So they don't even want the buyer to have that. You know how you get rid of that? If you deliver the TDS to the buyer before they sign the offer, they don't even have a 5-day right of rescission at all. This has become a common practice in the Bay Area, not only the Bay Area, nowhere else, in the Bay Area where they post all the disclosures in a package, and they say to the buyer's agent, download it, give it to your buyer, have your buyer sign it and date it before they sign the offer. If you actually get that, then they don't even have a 5-day right of rescission. See, in that case, you actually need the buyer's signature. In the normal situation that I'm talking about, remember what I just said? You don't need the buyer's signature. All you need is the buyer's agent to receive it. You as the seller side, even though the contract says buyer's going to sign it, yeah, that's true. But whether they sign it or not, they have this 5-day right of cancellation once their agent receives it. But if you don't want the buyer to even have a 5-day right of rescission at all, if you're that crazy, then you actually need a buyer's signature on the TDS dated before they sign the offer. But your market here is not insane like the Bay Area is, so forget what I just said. Don't even think about that, yeah.
When are they going to clarify the sprinklers?
What about it?
What?
How would you like it clarified?
Well, there's overhead sprinklers, there's...
So it just says sprinklers, right? And you don't know, and you want it clarified. You just write it in. You're right. I mean, send me an email of what you'd like. You'd like more boxes, for example, different types of sprinklers.
Well, is it overhead or is it...
Is it for fire or landscaping?
When in doubt, say they're sprinklers. You know what I mean? Or, no. Let me rephrase that. That's a good question. Actually, I got a better answer to that. Since you don't know whether it means fire sprinklers, lawn sprinklers, overhead sprinklers, underground sprinklers, since you don't know, you got two choices. go to the trouble of writing it in,
Well, I do.
or don't check the box. The opposite of what I just said is a joke. When in doubt, don't check the box. Here's another one. If you look on the first page of the TDS, bottom right-hand corner, there's a box that says water-conserving plumbing fixtures. Some says, I don't know if they are or not, or some of them are, and I think some of them aren't. Just don't check the box. Don't check the box unless you're 100% sure every single plumbing appliance you have is low flow, right? So when in doubt, on the first page, when in doubt, I say don't check the box. Okay? On the second page, answer every question. Okay? All right. Speaking of water-conserving plumbing fixtures, who in this room owns a single-family detached home? Okay, of those people that just raised their hands, how many of you don't have low-flow plumbing fixtures? Be honest. Criminals throughout the room. Okay. Why are you so blasé about being this criminal? Because you've noticed that the city of Bakersfield, Kern County, nobody's enforcing this law. And that's true everywhere in the state. No one's enforcing this law. Home inspectors don't call it out. Appraisers don't look for it. Nobody cares. And maybe no one's ever going to care, but I just want to update you on the law. Effective January 1st, a little over 2 months from now, the responsibility to have water-conserving plumbing fixtures is not just owner-occupied single-family homes. It is everything. Condos, apartments, investment properties, commercial property, agricultural property, industrial property. Effective January 1st, if you got a toilet, it better be low flow. Like I said, maybe, I don't know if that's going to change enforcement. Right now, no one is enforcing this, so nobody cares. So we all raised our hand, including me. I don't even follow the law. Okay, so, but maybe it's going to, my suspicion is maybe when it's universal, maybe that's when the enforcement might start. And plus, you know how tenants are. Tenants love to turn in their own landlords. They'll call up the city of Bakersfield, my landlord doesn't have low-flow plumbing fixtures. Or they'll threaten the landlord, say, reduce my rent or I'll turn you into the city about your lack of low-flow plumbing fixtures. I don't know what's going to happen. All I know is January 1st, it's not just owner-occupied single-family detached homes that have to have low-flow indoor faucets, toilets, and indoor showers. Okay? All right. We're still got more good stuff on this new law. Now I'm talking to all you brokers out there. I got good news for you. You know, when you're a broker, you have an agent working for you, you have to keep in your office a physical hard copy of their license. Effective January 1st, you don't. Just burn those licenses. You don't need to keep them anymore. Obviously, you've electronically told the DRE that you have these agents. You don't need a hard copy anymore. That's good news. Here's another one. If any of you guys have a corporate broker, you're a corporate brokerage, and you are the designated broker of your corporate brokerage. Question, do you have to maintain both the corporate license and your individual broker's license? Today the answer is yes. January 1st the answer is no. You don't have to pay 2 fees. You don't have to maintain your individual broker's license as long as the corporate license is maintained. Of course, you're probably going to want to keep it anyway, just in case all of a sudden you're not the corporate broker anymore and you want to go off on your own or whatever, or you get fired. I don't know what it is. But the point is, you don't have to, if you don't want to, maintain your individual license, okay? So that's a good news. Sad thing, I mean, we get this call on the hotline every now and then. What happens if the broker, corporate broker, all of a sudden dies or becomes disabled? Right now, you know, the current law is basically the brokerage has to stop doing business until you get a new broker. You can't do anything. New law is going to say, no, you can keep on going as long as you file an application with the DRE to replace the broker within 10 days. You don't have to stop work, keep going. So that's a sad thing, but that's something to talk about. All these I think are good things. A lot we're catching up here. One more thing, and that is independent contractor. You know, the relationship between a broker and an agent is typically independent contractor, not employee. We like that, right? We like that part. We don't want you to all have to be employees. Brokers don't want you to be employees and have to pay minimum wage and vacation and sick time and all that stuff. It's just not going to work. You're independent contractors. But did you hear the California Supreme Court had a case a few months ago called the Dynamex case, where they changed the test to determine Well, who is a independent contractor, who's an employee? You know what the test is now? The test, among other things, says someone can't be your independent contractor unless what they do, the work they do is different than the work you do. So if you hire a plumber, the plumber can obviously be an independent contractor because you're not a plumber. But think about real estate. What do brokers do? Sell houses. What do agents do? Sell houses. So brokers and agents do the same thing. Does that mean under this new Supreme Court test, every agent in the state is no longer an independent contractor? Yes, that's exactly what that means. Fortunately, this new law that I'm talking about reaffirmed. In other words, when the Supreme Court says something, the legislature has the power to overturn that. So that's exactly what happened. So you're still independent contractors. Yay, okay. I bet none of you even heard about that case. You weren't even worried about it. So, right? So, but you know what? You know what? The whole real estate law. If you go through the real estate law, the terminology it all uses is employment. You know what the definition of a salesperson is under the real estate law? Someone with a real estate salesperson who's employed by a broker. The word employ. We hate that word because it implies employment. So we got it changed. We went through the whole real estate law, and every time we came to the word employ, we changed it. Guess what the new cool word is? Retained. You don't hire anyone in real estate, you retain them. You're not employing anybody. Heck no, you retain them, all right? Retain people. Don't hire them. Don't employ them. Retain them. Okay, that's the key word now, all right? Remember that. All right. Speaking of DRE and government stuff, do you remember I told you last year that there's a new law last year, effective this year, that says when you hire a broker associate, you have to notify the DRE? Remember up until this year, if you had a salesperson, you have to notify the DRE. But if you hire a broker associate, you don't have to tell anybody. Broker associates are brokers. They're independent. They can work wherever they want. They don't have to tell the DRE where they're working. That has changed, right? Brokers and broker associates, you must tell the DRE about your relationship. There's a form for this, Form 215. You have to download a hard copy. You can't do it electronically. So that was last year. What's the update this year? The update this year is the timing. It says when you retain a broker or associate, you got 5 days to notify the DRE, and when you get rid of, you notice I didn't say fire, when you get rid of a broker or associate, you have 10 days to notify the DRE that the relationship is over. Okay? All right. Another clarification, you know the rule that says you got to put your DRE license on everything? You know that rule? The original law didn't clarify some things. I mean, we know you got to put your DRE license number on, you know, your website, your business card, your Facebook page, your flyers, your newspaper ads, your magazine ads, your Craigslist ads, and your signs, right? Okay. But what about other things? What if you have a name badge? I think some of you have name badges. Is your license number on there? But she's okay, thank goodness, because she's an important person. And if she were violating the law as the president of Sierra, that wouldn't be good. Okay, they clarified you don't need your DRE number on name badges or pens or any promotional items you have. None of you guys are doing it anyway, so obviously you don't care. But what about social media? What if you send out tweets? What if you send out Facebook posts? What if you send out emails to a group of people? What if you send out text messages to a group of people? Is your DRE number required on every single one of those? We don't know yet. At least the DRE figured out that that's not clear, so they said we're working on a regulation, should come out by the end of the year. Until then, don't worry about it. So today, don't worry about it, but you may get an email from all of us from CAR like in a month that says DRE finally issued their social media advertising reg, and this is what you got to do. We're hoping that they don't. We're trying to convince them not to do it, but it's unknown. But for now, don't worry about it. So don't worry about name badges and pens and pads, but worry about flyers, newspaper, magazine, website, your business card, and most importantly, signs. That's what they're focusing on, signs. And realtors are getting in trouble. They're paying $200 fines. No warning, just $200 fines. Well, how many people work at the DRE? There can't be that many people working at the DRE looking at signs. How do these people get in trouble? Because other realtors turn them in, that's why. If there's people out there you don't like, go look at their signs. Sometimes for fun on the weekend, you're going to say that doesn't really sound like fun. I'll drive around looking at open house signs. I would say 3/4 of the open house signs I look at do not have DRE license numbers on them. They are all in violation. You can still have a generic open house sign that just says open house. That's fine. You don't need anything. But every agent, they put an open house sign, then they put their name on it. They put the name rider on it. Well, once you put your name on it, you trigger everything else. Name of company, your name, your DRE number. So with the open house sign, it's all or nothing. What about a for sale sign? For sale sign, it's okay to just have the company name. But if you put your name, you also need your DRE number. Everything else, business cards, flyers, you cannot just put the company name. Everything else, you need 3 things: company name, your license number. You notice I don't say you have to put the broker's DRE number because that's not required. Then people ask me the very intelligent question, Gov, I'm an independent broker. I am the only person who works here. I'm all by myself. I put up a sign, do I need my DRE number? And the answer is you don't. Can you believe that? Of course, I think the DRE is going to figure this out one day, that, wow, we shouldn't really exempt independent brokers from this. But today, I swear to you, you can quote me, I'm on tape, I'm on film. Today, brokers don't have to put their DRE number on stuff, even though they're the only person there. I'm suspecting this is going to change, so I might do it anyway. But technically, you don't have to. But agents, yes. Agents, yes. Broker associates, yes. You're not the responsible broker. And you always need the 3 things. And open house signs can be generic, but if you put your name on it, you got to put everything else: name of company, your license number. Questions on that? Good with that? Yes, ma'am.
So if we have the broker's logo and name, and we have the name rider, we have to put our DRE number on?
Absolutely. Absolutely. You put your name rider, you always need, it's simple to remember, if your name is there, your license number is there. You can never have your name without your license unless you are the broker.
So you talked about after the font size of the DRE number has to be, does it have to be that big?
No, the font size, remember what I said, the law says there's no size, it just can't be the smallest thing. So if your whole sign says name of the company, your name, DRE number, it would have to be as big as everything else. But if you have something else real small, like have a nice day, your number could be that small, right? How about the relative size of the company name and your name? Can your name be bigger than the company name? Yes, unless your broker has a problem. If your broker doesn't care that your name is bigger than the company name, the DRE doesn't care. But they care if you mark it as a team. Listed by the Hutchinson team at Culver City Realty. If that's what I did, my name could be no bigger, and it can't even be above the company name. But if it's just listed by Gov Hutchinson at Culver City Realty can be much smaller than my name. How big does the company name have to be? Reasonably prominent, whatever the heck that means. Bigger than the license number that's tiny, right? But there's no specific rule, okay? Yes?
If you're just marking your company's name with no actual individual's name, what do you mean?
Yeah, I mean, if it's just for sale by the company name.
Or open house specifically.
Oh, I see what you're saying. Yeah, open house, and same thing. That's whether it's an open house sign or for sale sign, if it just has the company name, you're good. That's all you need. It's only when you put your name on there that triggers the other stuff. But you cannot have a generic for sale sign. A for sale sign always has to have at least the company name. Whereas the open house sign or the directional sign doesn't have to have anything at all if you don't want. But if you put one thing, you got to put, if you put company name, you're okay. You put your name, triggers everything. And they are cracking down on this. They actually hired new staff. You know, since the last time I was here, right, it's now the DRE. No more Cal BRE, it's DRE. But you know what? Who cares? It doesn't affect you. And it doesn't affect your signs or your business cards either. If you just bought 1,000 signs and 10,000 business cards that say Cal BRE, keep using them. They don't care. It doesn't have to say anything, you just say license number. Okay? All right? I think we're done with the DRE, we're done with the licensing law, we're done with the new law fixing up these things that I'm very excited about. You're probably not as excited as I am about some of these things, but at least the two dumbest laws I've always talked about. Oh, I know. Here's another dumb one that it fixed. You know the transfer disclosure statement? Do you know some sellers are exempt from this, right? Who's exempt? REO, probate, bankruptcy sale, new house with a public report, and a sale by a trust. So if the seller is a trust, they're exempt from the disclosures. But did you know if the trustee used to own the house, they're not exempt. So if you have a revocable trust, let's say I own my house, I transfer it into a revocable trust where I am the trustee, meaning I used to be on title, and now I come to sell my house, I have to do all the disclosures. I'm not exempt. But if it's a successor trustee, right, who's never been on title, that person's exempt. But did you know the law says today, if I'm the sole trustee, I'm not exempt. But if a husband and wife are joint trustees, even though they both used to be on title, since they're joint trustees, they're exempt from the disclosure. That's really dumb, isn't it? That was another one of my dumb laws in real estate. They fixed that one too. So if they have a revocable trust on title and any of the trustees, any of them used to be on title themselves, you're not exempt from disclosures. That's another dumb law I'm glad they fixed. All right. Whoa, I keep hitting it. Sorry. Step back a little bit. Other laws you should know about. Let's talk about rentals, because some of you might be landlords, some of you might be tenants, some of you might be property managers. You should know what's going on. Let's say it's Thursday, your tenant's not paying rent, so you give them a 3-day notice to pay or quit, right? So you give it to them on Thursday. What's their deadline to pay or quit? Sunday. Thursday's day 0, Friday 1, Saturday 2, Sunday 3. That's the law today. Starting a year from now, it's going to be Monday, because starting a year from now, actually it'll be Tuesday, because starting a year from now, the 3-day notice is going to be business days. You don't count Saturdays or Sundays or judicial holidays. What's a judicial holiday? Those are the boring holidays. The fun holidays are not real holidays. Cinco de Mayo, Halloween, St. Patrick's Day, Chinese New Year, they're not judicial holidays. If the courts are closed, it's a judicial holiday, and those don't count. So 3-day notices, starting September 1st of next year, you got a year to get ready, you don't count Saturday, Sunday, and judicial holidays. Same thing when you serve someone with an unlawful detainer, they have 5 days to respond or else they're out. The 5 days aren't going to count Saturdays, Sundays, or judicial holidays. Okay, so that's good to know. Other things you should know. Did you know as of July 1st, there's a new law that says that when you have a new tenant, you must disclose to the new tenant if they're in a flood hazard zone. Did you know that? I mean, when you sell a house, you know you have to tell the buyer if they're in an earthquake zone or a flood zone or a fire zone or a Melrose. And the way you do that is by ordering an NHD report. But when you're a landlord, you have a new tenant, you typically haven't told them anything, right? You don't tell them anything. Well, now you have to tell them that if they're in a flood zone. Not earthquake or fire, but flood zone. Well, does that mean if I'm a landlord or property manager, every single time I have a new tenant, I got to order an NHD report to see if I'm in a flood zone? Is that what that means? Good news for you. No, it doesn't. Why not? Because there's a free way to find out if you're in a flood zone. Some of you have a pen here. You're going to write this down. If you go to the following website, msc.fema, F-E-M-A, my name, / portal, P-O-R-T-A-L /search. msc.fema.gov/portal/search. You'll come to a screen, you type in the address of the property, flood zone will appear in front of you. You'll see right on what you're looking at whether your property is in the shaded area of the nearest flood zone. So you got to do this, landlords, every single time you have a new tenant.
Just print that and deliver it?
Yeah, you actually have to fill out a form. So there's a new mandatory form, the tenant flood hazard form, you have to give to your tenants. Well, here we are in October. I never knew about this law. I had a tenant in August. Should I give it to him now or better just let it go? I would give it to him now because they can't really do anything about it. Whereas if you don't give it to them at all, they could say, hey, they could try to use that as an excuse. I don't know what they're going to use it as an excuse for. The only thing, I think the only problem is going to be if there's a flood and they had flood damage, they're going to say, you should have told me about this, I never would have moved here. As long as you haven't had a flood yet, you're good. Yes?
Commercial and?
Not commercial. Not commercial. So residential. Speaking of commercial, here's a new law. You're a commercial landlord, your commercial tenant leaves, and they leave behind some personal property. If they leave behind personal property, does it belong to you now? No. First you got to write them a letter. You left some stuff behind, come and get it. What if they don't come and get it in 18 days? Does it belong to you now? No. Now you got to ask yourself, if I resold their abandoned personal property at a garage sale, what would I get for it? And if in your honest, good faith opinion, it's worth more than $750, you actually have to, you can't just keep it, you have to actually do a public sale, get the proceeds, and either give them back to this tenant or give them to the Kern County Clerk's office. I'm sure none of you ever do this. Well, I've got good news for you. The $750 has gone up to $2,500. So now when they leave their their stuff behind, and they haven't come and get it in 18 days, you're going to ask yourself, is this stuff really worth $2,500 as opposed to $750? And if the answer is no, you keep it, dispose of it, do whatever you want. By the way, what about residential? How much is it for them? $600, and it didn't go up. So when you're a residential landlord or a residential buyer and the seller leaves stuff behind, it doesn't belong to you unless you talk them up and say, did you mean to leave that? Is it mine? If they say, yeah, okay, fine. But if they just leave it, you got to write them a letter. Dear seller, you left your stuff. Come and get it. And if they don't come back in 18 days, you ask yourself, is the resale value more or less than $600? If it's less, do whatever you want. If it's more, you got to sell it. But at least for commercial, it's gone from $750 to $2,500. So that's good news for commercial landlords. Okay? All right. Anything else with rentals? Remember I told you last year it really happened. The bed bug form is required. I know multiple property managers who've been fined thousands of dollars simply for not giving all their tenants the bed bug form. Now, the tenant flood zone, you only have to give that to new tenants after July 1st, and you only got to give them the form if they're in a flood zone. The bed bug form you have to give all tenants, even your old tenants, whether they got bed bugs or not. And I hate to tell you this, it applies to short-term rentals. It applies to seller rent-backs for 3 days. It applies to Airbnb. There are no exceptions. Give them the stupid bed bug form. BBD, bed bug disclosure. Yes?
We send it out to all the tenants?
Yeah.
Some of them say I'm not signing it.
What about a tenant who refuses to sign it? If you can document that they got it. I mean, that's an old problem in real estate. What if you give someone a termite report and they refuse to acknowledge it? What if you give them a notice to perform and they refuse to acknowledge it? You never have to get someone's signature on something. You got to prove that they got it. One way is you send it by email, they open their email, they can't deny they didn't get it, right? Or you certified mail or something, or a process server. I mean, it's an age-old problem in business, in real estate, when you have to give someone something, what if they won't sign for it? It's not your job to make them sign it, it's your job to deliver it. There are many ways to prove that somebody delivered it, so you don't have to get a signature. But try to be able to prove that they got it, okay? Anything else? Okay, here's something, landlords, listen carefully. You got 6 years to do this. We may all be dead in 6 years, but in any event, in case you're not, listen to this, landlords. If you have a building with at least 3 units, and you have any balconies, decks, or stairways, you must inspect them before January 1st, 2025. Yes, you have 6 years to do this. And then you're going to have to do it every 6 years thereafter. But here's the thing, you can't just have a home inspector or a contractor do it, it's got to be a specialist. Who the specializes in inspecting balconies and decks? We don't even know yet, but we'll know by 2025. I mean, I think every contractor is going to be able to get a special certification to do it or whatever. But the point is, you got 6 years to do this, but if the inspector says you got a problem with your balcony or your deck or your stairway, you got to fix it. It's not just a disclosure issue. You're going to have to apply for the permit for within 120 days and then complete the work within 120 days after that. Well, who's going to enforce this? Nobody. So ignore it. No, don't ignore it. I'm on film here. I got to remember this. Okay, yes. No, you got to do this. And if the inspector says, not only is your balcony or your deck needs some work, it needs work immediately. It's in a dangerous condition right now. If that's the conclusion of the inspector, they're going to have to give you the report within 15 days and you have to fix it immediately, and they're going to immediately notify the enforcement, you know, the Bakersfield building department, whoever enforces things like that. So then there is going to be some enforcement. They're going to check and make sure you do it. I don't know how quickly. It doesn't say how quickly you have to do it, but you got to do it like immediately. Okay? So get ready for this. We'll obviously give you a lot more information on this, but this is coming, and the deadline is 6 years from January 1st to do that. Is there anything else landlords need to know that's changed? That's really about it. I will say this. You know, we've got this form called the tenant application to rent. I mean, if you're a landlord, you have a vacancy, you want to get a new tenant, obviously, usually you want them to fill out an application. You don't have to, but that's standard procedure. And CAR has a tenant application form. You don't have to use our form, but in case you do, here's a change we just made. All these years there's been a question on the form when the tenant's filling out, do you have any animals? So let's say the tenant, they have a service animal. So they answer the question, yes, I have a service dog. Then they submit their application. And then the landlord rents to somebody else. Not because of the dog, because somebody else had better credit or whatever, right? Well, guess what? The tenant that got rejected, and on their application they said they got a service dog, they sue. They sue the landlord, said, you know, I know why I didn't get that property because of my service dog. They don't like dogs. So that's discrimination based on disability. And they sue the landlord. We've seen a ton of these lawsuits. How do we change it so these don't happen? Well, we changed the question. I'm not saying the landlord's going to lose these lawsuits, but you don't want to get sued anyway. And a lot of times they lose. The question on the form now says, do you have any pets? Not animals, pets. Because obviously the landlord can reject pets. So if they say on their application, yes, I have a pet, landlord can say, no, you can't live here because of your pet, no pets. Of course, what if the tenant has a service animal, not a pet? Well, they're going to answer that question, no, I don't have a pet. And you say, great, and you rent to them, and then they show up with a dog. You said, I thought we agreed no pets. Oh, it's a service animal. Well, then you got to take it, right? But you're in no worse situation than you were before, because even today, if they agree, when they move in, they have no animals, 2 months later, they can always get a service dog, right? And even though you have a no pet policy, there's nothing you can do about it. At least this will avoid the lawsuits where they accuse you of not renting to them in the first place because of the animal. Because you're not going to ask them if they have any animals. Only pets, which you're allowed to say no to. Question?
If they have a service dog or service type animal, can you get a service type animal deposit?
Unfortunately, no. Her question is, if they have a service animal, can you require a deposit, extra rent, pet insurance? No, no, and no. Of course, if their service animal damages the property, you can definitely get reimbursed for that. Or what if the service animal bites the other tenant? Can the victim tenant sue the landlord? No. Know why? Because we got something in California called the one free bite rule. If you're a landlord and one of your tenants' dog bites someone else, they can't sue you. They can sue the owner of the dog, though. Dog owners, you do not have one free bite. Landlords with tenants with dogs have 1 free bite. You know what that means though? So you're a landlord, you have the tenant with the dog, service dog or regular dog. That dog bites someone. You now go to the tenant who says, well, you've had your 1 free bite. If your dog bites again, I get sued, so you got to get rid of that dog. Oh no, I don't have to get rid of the dog, it's a service animal. Yeah, you do. You get a different service dog if you want, but you're not allowed to have that one. So that's your right as a landlord. Plus with a service dog, remember you're entitled to proof from a medical doctor, an MD, that this person has a disability that prevents them from performing a particular task, and the dog in question has been trained to perform that task and certified to do it. If you have those 2 things, you have to accept the dog. You notice I said dog. Service animals have to be dogs. But what if they show up with a gorilla, or a peacock, or a snake, or a chicken? What do you do now? You can't live here. Say, oh no, it's not a service dog, it's a companion gorilla. Do you have to accept that? No, why not? You only have to reasonably accommodate your tenant. And every judge in California is going to agree a gorilla is not reasonable. Neither is a peacock. Neither is a snake. But if they show up with a companion dog, even though it's not certified to be trained, if it's emotional support, you got to take it. Yes?
What if it's a service dog on the restricted list from the insurance company?
Right. Very good question. What if it's a service dog or a companion pit bull, German Shepherd, Doberman, which is on the restricted list from your insurance company? Is that a reasonable basis to say to the tenant, get a different dog that's not on the list? You're waiting for the answer here. Most judges say yes, but some judges have gone so far as to go back to the landlord and say, did you check with every insurance company in Kern County? Did you ask them for a waiver of their normal rule based on disability? And they've actually made the poor landlord go through that trouble. The general rule is that is a reasonable basis to reject a service or a companion dog if it affects your insurance. But it's not guaranteed crystal clear, so we try to fight that. What about this? What if you have a tenant already who is allergic to dogs? Then you get a new tenant who needs a service dog. Now what? You have disabilities in conflict with each other. Who wins? Well, you know what the law says? You have to try to reasonably accommodate both of them. How the heck do you do that? Well, if you have other units available, like the one who's allergic to dogs, say, well, you want to move to this one where you're not next to the service dog? Or you say to the service dog person, you want to move here where you're not next to the allergic person? Okay, you try to make it work. But what if it just can't work? You have 2 tenants adjacent. One is allergic to dogs and one needs a service dog. What do you do? It's pretty easy, the first one there, right? So if the allergic one was there first, then the second one says, I need a service animal. I know, but I have a tenant who's already there who has their own disability, which your disability is going to hurt their disability. It's crazy. I mean, but this is the life you deal with as a landlord in California. All right. Yes. I'm sorry. Yes.
You have to have proof of companion animal.
Very good question. Her question is, do you have to have proof that you need a companion animal? Yes. Unfortunately, you don't need a note from a medical doctor. You need a note from a licensed caregiver, which means not their mother, right? I mean, somebody. Someone who's been, not something they got off the internet, someone who's actually been providing care for this person with some type of license, but not an MD. For a service animal, MD. Yes?
Can you require additional pet insurance first?
If it's a legit service or companion animal, you can't require anything like in the area of insurance, rent, or deposit or not. I raise this not because there's anything new, just because I knew you're going to have questions, because this is the #1 landlord-tenant question on the legal hotline month after month after month. Okay, other laws. We're almost ready to talk about forms, but we got, other laws you should know about. So we've covered everything in the DRE, TDS, agency, brokers and licenses and keeping copies and stuff like that. That's the most important stuff. There's some other laws you should know about. I don't know what category is. Swimming pools. if you have a swimming pool, did you know there's a new law that says all swimming pools built after well, this is new. All swimming pools after 92 have to have a safety feature. This includes spas, this includes jacuzzis. What's a safety feature? It could be a pool cover, a fence, a gate, or an alarm. What do I mean by an alarm? Well, it could be anytime you open the door from the house to the pool, something beeps, or anytime you open a gate to the pool, something beeps, or anytime someone jumps in the pool, the beep, it goes off. Or as long as any door that opens from the house to the pool self-closes and self-latches. What's new? What's new is home inspectors are required to look for this now. Home inspectors are required to figure out how old your pool is and if it has a safety feature, and then call it out on their inspection report. Okay, what about my pool is built before 92, but I renovated it after 92? You have to comply. Okay, so what if the home inspector says, yes, this pool needs a safety feature and it doesn't have one? They put it in the report, they give it to the buyer. Does the seller have to put in the safety feature? No, they don't. The buyer can say, put in the safety feature, the seller says no. Buyer could say, I'm not going to buy your house unless you do, but unless they do that, it's not a mandatory point of sale. It's a mandatory disclosure by the home inspector to the buyer. But guess what? If you put in a new pool in 2018 or to this year or later, you have to have 2 safety features, not just one. What if your pool is older than 92 and you haven't renovated it since? Don't do anything. Let the kids drown, you don't care. I'm just kidding, Kidding, yes. You should probably, in other words, you probably should put in a safety feature, yes.
Most home inspectors have no idea how old the pool is.
They're gonna have to figure that out. You're right. Somehow they're gonna have to figure out how old it is. I don't know how they're gonna do that. Talk to a home inspector, yeah.
What would be the designation of the safety feature? Could it be a sign in the window?
No, the safety features are what I said. It's gotta be a pool cover, or a fence, or an alarm. Or the last one, the easiest one, is any door that opens to the pool has like a screen door that self-closes. That's okay.
So when you say a fence, does that include your backyard fence? Or
no, a fence around the pool. Yeah, a fence around the pool. The screen door might be the easiest thing, yeah. Yes?
How is a self-closing door a safety feature?
The safety feature, I don't know how safe it is. It's designed to 2-year-olds walking around, and you know, 2-year-olds, they walk out the door, you're gonna hear the door close. I don't know. I'm not a pool person. I'm just telling you what you got to do to comply here. It's probably not good enough. You're right. Yes.
I read a code that said 2 of 7 approved safety features.
Yeah. New pools have to have 2. Only new ones starting in 2018. Okay. Existing pools don't have to have 2. But if you renovate an old pool now, you got to have 2. Yeah, you do have to have 2.
But you can decide those 2.
You decide the 2. Absolutely.
If you want your alarm to tell you when the door's open and have a self-closing.
Right. Sure. Absolutely. You pick the 2. Right. You pick the 2. All right. Other things that are going on before we talk about forms. Employment law. I just got through telling, we all agree that real estate business is typically independent contractors. Okay, that's good. But some of you brokers, some of you agents may hire people, right? I mean, maybe you hire assistants, maybe you hire TCs, maybe you hire a secretary or receptionist. Maybe some of you are in the employment world, whether you like it or not. Or maybe some of you affiliates. Anyway, some of you may be involved in employer-employee, so you need to know the new laws. There are just a couple I want you to know about. One of them is, you can never ask a prospective employee how much money they used to make. You cannot ask for salary history anymore. But you can ask their salary expectation for the new job. But you can't ask for their history. Well, what if they ask you, well, I'm expecting $20 an hour. What does this job pay? You have to answer the question. You have to tell them what the job they're interviewing for pays, but you can't ask them what they used to make, if that makes sense. I don't know if it makes sense or not, but that's the new rule when interviewing, and it affects me. I'm currently hiring someone at CAR, and it affects the questions I have to ask these prospective people, okay? Any of you guys want a job? Working for me? Admin work. Move to LA, work for me. Okay. Anyway, so that's one thing to remember. Another thing, listen to this. This may not apply to any of you, I hope. But if you have at least 5 employees where you work, 5, only if you have at least 5. Starting next year, you have to take every 2 years, 2 hours worth of training on sexual harassment. Now, this is not training how to do sexual harassment. Training how to avoid doing it, right? Don't do it. Telling you what not to do. So, but only if you have 5. But if you have 5, every employee has to take it. What about the realtors? You don't have. You can do whatever you want. You don't have to take this class. You're independent contractors. You're independent contractors. But some brokers hire managers and treat them as employees, and you know what I'm talking about. So this is a new requirement you got to do. Here's another thing. I know I'm not talking to anybody in this room. I know this is a good group here. You're all good. But there's a law that says you can't harass somebody. But you know the law on harassment only applies to the employment context, right? Or schools or things like that. I mean, if you're just out on the street being a jerk, you're a jerk. You're not necessarily a criminal, right? I mean, people go to bars and say crude things that if they said in the office, they'd get in big trouble, right? Anyway, the point is harassment. You can't harass people in a work environment. Well, what about realtors? Are you in a work environment? Yeah, you can't do harassment in real estate, which means you can't harass your clients. I hope you know that, right? You can't harass your clients. But they've expanded the law, I kid you not, that says, and this applies to lawyers too, it says not only can you not harass your clients, you can't harass anyone who you've led to believe you can enter into a professional relationship with. You know what this means? You can't harass your potential clients either. And for realtors, isn't everyone you meet a potential client? Your entire life, every single person you meet is a potential client. Very simple, don't harass anybody. Attorneys too, everyone I meet is a potential client. Not me, because I just work for you, but anyway, I think that's a good thing to remember. Don't harass people, and then you're good, all right? You're all good. Okay, let's talk about forms. Let's talk about some form changes. There's not much. You notice the laws I said, nothing too terrible. There's good stuff and stuff that's not too bad. Are there any form changes? Well, I've already told you some things, right? I've already told you about the agency disclosure form isn't going to have that box towards the bottom for the seller, so you don't have to worry about that anymore. I already told you that paragraph 2 of the purchase contract, the agency confirmation, instead of just saying seller's agent, buyer's agent, it's going to say seller's brokerage firm, seller's agent, buyer's brokerage firm, buyer's agent.
On that subject, you already have that information on the signature or the acceptance page of the contract. In other words, is that still going to be there? So it's going to show up twice?
Oh yeah. Plus, not only is it going to show up there, remember always on the last page of the purchase contract, there's that box.
That's what I was talking
Oh, that place, yeah. Exactly. Even though it's there, and on, what he's referring to, that broker box on the last page of the contract, you notice you put your name and your DRE number, your company, and your company's DRE number. Putting your company's DRE number on that box has always been optional. It still is. But on the new paragraph 2 that comes out in December, it's not optional. So you're going to have to put the broker's DRE numbers. I think most of you have probably been putting it on that last page anyway. But you never really had to, and you still don't have to, in case you get. All right, so there's that change to the agency form. There's that change to the paragraph 2 of the purchase contract. I told you there's a new question on the tenant application form. It doesn't say, do you have any animals? It says, do you have any pets? You understood the reason for that. I told you about the new tenant flood hazard disclosure form, which is mandatory if they're in a flood zone. We talked about the new bed bug form, although I told you about that last year. That's a new mandatory form. Are there any other new forms? Those are the only mandatory stuff. Yes? Yeah.
DRE number on the front page, paragraph 2.
Yes.
Technically, we're not supposed to add things to a contract, and most of the time we'll get offers from agencies that don't fill in. That's why I said, yeah, if I didn't say that, I'll say it now. You're right.
She's right. You're not supposed to go back and fill in stuff on the contract after the buyer signed it. So what I'm telling you is when you're a buyer's agent, even though you're just the buyer's agent, fill in the seller's agent portion so you don't require a counteroffer. In other words, when you get to paragraph 2, put your company name, your name, put the listing company name, you know what company listing it is, and their DRE number. You can find it on the MLS. And put the listing agent's name, the seller's agent's name, and put their DRE number too. That's also on the MLS. So yes, I'm saying you should fill that out. So otherwise, you're right. The seller's agent's not allowed to go back and fill it in. So they'd have to do a counteroffer or an agency addendum. To avoid that, I'm saying you fill it out.
Right. That company name should also be correct, not abbreviated, not hyphenated.
Right. Well, whatever it appears in the MLS. Right. Yes. Hey, if everyone uses MLS Connect, there'll be no mistakes, no problems. What a good tip. All right. All right, so those are the only mandatory changes. Yes. So let me tell you about other forms that you don't have to use that you might want to use. Okay? Other forms that have come out this year or are going to come out in December. There's hardly any at all. First of all, there's the Buyers Homeowners Association Advisory. You know, we have advisories. We have the Inspection Advisory. We have the Statewide Buyer and Seller Advisory. We have the Probate Advisory, the Trust Advisory, the Short Sale Advisory, the REO Advisory, the Market Conditions Advisory. You know what an advisory is? It's advice. What I mean by that, it's not an addendum. It doesn't need to be signed by the other side. I get these calls on the hotline. I'm having a problem getting the other agent to sign the Statewide Buyer and Seller Advisory. The other agent, I say, yeah. I said, did you give it to your client? Yes. Did they sign it? Yes. Well, you're done. Why do you need the other client to sign your advice? You see what I'm saying? Advisories are not addendas. They don't need to be signed by both sides. It's advice you're giving to your own client. So I tell the agent that, and they said, yeah, but my broker says he won't pay me unless I get the signature from the other side. You know what I do then? I say, have your broker call me. You shouldn't be holding up a deal or a commission because you don't get the other client's signature on the advisory, and advisory is advice from you to your own client. Having said that, there are two new advisories you don't have to use, but they're good. One is the BHAA, Buyers Homeowners Association Advisory. If you haven't seen this form, this is a form. Have you ever noticed when a buyer buys a condo or something in an HOA, they receive the governing documents and then they don't read them? Yes. Then they move in and they find, when they move in, oh my goodness, I can't rent out my unit, I can't, no pets, no smoking, no whatever. Then they're mad at you. Why didn't you tell me before I moved in about all these things? Why didn't you, and you say politely, why didn't you read the governing documents? And they say, I thought that was your job. I thought you were going to read it and explain it to me. That's not your job. But the reason I like this form basically says to the buyer, number one, you should probably read these forms before you remove your contingency. And number two, it even tells them what to look for. It says in the CC&Rs, look for this. In the rules, look for this. In the bylaws, look for this. It gives them a heads up. These are, you know, things I just said, like right to rent your unit, smoking rules, pet rules, things like that. So it protects the buyer and it protects you from getting blamed by the buyer for not explaining these things to them, which is not your job to do. So I like that form. You don't have to use it. The second form I like that came out in July is called the DIA, the Disclosure Information Advisory. This is a form that you would give to the seller. Why would I give this to the seller? It explains how to fill out the TDS and the seller property questionnaire. It gives them tips like I've been giving you today, like answer every question, right? Answer every question, it's important. It also reminds the seller that you have to disclose past problems. You'd be amazed how many lawsuits there are against sellers and agents when the seller didn't disclose they had a plumbing problem 5 years ago. It's not a problem now, but it was 5 years ago. And then they have a plumbing problem later and the plumber comes in and says, oh, I can tell this was worked on before. So you have to disclose not just current defects, but past defects. And he also reminds the seller always disclose neighborhood conditions. You'd be amazed how many sellers get sued when the buyer moves in and they sue the seller 6 months later and say, why didn't you tell me your neighbor was a jerk? I never would have bought this house if I knew what a jerk he was. That's a material fact. That is a material fact. A nosy neighbor, a noisy neighbor, ugly neighbor. I don't mean the neighbor, I mean their house is ugly, you know. Their yard is ugly. I mean, these come up, and this is just I like this form. It reminds sellers, tips to fill it out. It also reminds sellers, which is a good reminder to you, that when you're describing things, don't use adjectives. Don't say there's a small leak or a minor stain on the ceiling or an insignificant noise problem with the neighbor. Don't use adjective. Just say there's a stain on the ceiling, there's a crack in the wall, there's a noisy neighbor. Don't put limiting adjectives on it. And don't say, you know, there's a stain on the ceiling, it's blue-gray 5 inches by 8 inches. Because then if they measure it and you're an inch off, oh, that's a misdisclosure. That's a failure to disclose. Anyway. All right, so it's a good form. I recommend you give it to the seller, just like the buyer homeowner association advisor. I recommend you give it to the buyer if they're buying a condo. Yeah.
What's the exact name of that HOA disclosure form?
Buyers Homeowner Association Advisory, BHAA. And the other one is the DIA, Disclosure Information Advisory.
Back to the TDS for 1 second.
Yeah.
If you are the buyer's agent,
yes.
You get a TDS.
Yes.
That obviously, for instance, it's in an active adult community. Do a lot in active adult communities, and that seller has not checked the box that there's homeowners association, common areas, and CCNRs. You'd be surprised how people mark that no.
Oh, I'm not surprised at all. Right.
So, as a realtor,
right.
We can't change it all.
Right.
So what I've done is just put it on my ADID that there is those things. And how do you...
That's exactly the right thing to do. She says she's a buyer's agent. She receives a TDS from the seller that's clearly incorrect. What is your obligation? Well, since you happen to know that it's incorrect, you're going to tell your client the truth. By the way, the good news is the buyer's agent is not responsible actually to read that stuff that the seller. So if you miss that they missed it, you're not going to get in trouble. I'm glad you're a diligent agent who reads it and actually notices the mistakes and fixes them. But I'm saying even if you didn't catch it, you'd be okay. You would be okay. And the seller, of course, is opening themselves up for a lawsuit by not disclosing. But you don't want a lawsuit. You want a happy buyer. You want the deal to close. So do what you're doing. But don't go back to the seller and say, you need to redo this. That's not really the thing you have to do. You just need to do what she did, which is put on your Avid what the real truth is.
Okay, so I live in an active adult community, and I know of a property that has an issue. I'm representing the buyer. The seller has not disclosed it.
So you happen to know because you live there that the property for sale has a particular problem that the seller didn't disclose, right? It's similar to what she just asked. I mean, it's like they in this case, instead of putting something wrong, they just didn't disclose it at all, right? I mean, you got various options. You could say to the buyer, they didn't disclose this, we could use this as grounds to get out of the deal anytime we want. You know what I mean? They could use that strategy, but the safest thing to do, since my same answer to her is, since you know it, just tell them. Do you want a lawsuit or do you want a buyer to know what's going on? Of course, maybe now you don't trust the seller. What else are they hiding? You know, I mean, that's grounds for a buyer to walk away from a deal. And they could walk away from a deal just on the fact that that was not disclosed, even though you did tell them the actual truth of the matter. So it's sort of options of how to handle that. Yeah?
So relative to what you said, if there was an incorrect answer on the HOA that you were...
Right.
Can't you put that on your ad?
That's what she said she's going to do. Yeah, that's I think is the best approach. As opposed to going back to the seller and say, you need to redo this. That's not really necessary or really the right way to go about it. Okay, yeah?
This may not be a question for here, more technical.
when you send the TDS, SPQ, whatever, to the seller to sign via zip forms or DocuSign, it doesn't prompt them each box they have to check. It's real hard for them to go back and finish it. 9 times out of 10, it comes back signed only. Is there a way to get around that?
Yeah, that's a zip form question, like you said. Call customer service. You know, they try to change things to make them right, but we don't really have input on that, unfortunately. Yeah.
Are they going to be allowing other providers of like form solutions and transaction management solutions to get in on it, or they're going to stay monopolized with zip forms?
Yes, as far as I know, CR's official position now is still monopolized with zip forms. Now you're getting political, and it's above my pay grade here. Talk to the. You got a very important person in this association who will be wielding some influence. Yes.
I have a question for you about the FERPTA, the AS form.
Yeah.
Tell me if I'm doing this wrong. My understanding is that if Mr. and Mrs. Seller file a joint tax return under one social security number, that you would only need one AS form. If they do separate, then you would need one for each seller. Is that?
That is true, but I got a better answer for you. Why are you even doing that form? Aren't your escrow companies in Bakersfield agreeing to do the qualified substitute?
So my understanding has been that we need to use the AS form and the QS form.
No. Hope that's not a common belief. If you have an escrow company willing to take the responsibility, as hopefully they are, then you do not need the AS form. Now, maybe your escrow company, some escrow companies would like you to prepare the AS form and give it to them. But if they're not even requiring that, then
they're having me prepare the QS form,
right,
send it over them, and then their position generally is they won't sign it until after the seller has given escrow their information, their social security. But from what I've read that AS form very carefully. There's a section in there that's not covered by an exemption, and now you don't put the social security number on it, and you wouldn't check any boxes, but you would still sign that because that would then reference the QS.
If I'm a realtor, all I need in my file to protect me is the QS form signed by the escrow company. Now, some escrow companies throughout the state will say, we're not going to do that unless you prepare the AS form for us without the social. So we have that. The escrow company wants you to make it easy for them to collect the information. If that's the case, if you're running into that from a particular escrow company, you deal with that. But for your file does not need that form. Your file does not need that form.
On sale properties that are under 100,000, escrow companies will not provide you.
Because you don't need it, because you're exempt.
But our office is still required to do that, so how do we look at that?
You got to deal with your office right there. I'll talk to your broker if you want. I mean, there aren't too many properties to sell price less than 100,000, right? But if there are, all right, well then, I'm hereby telling you, you don't have to worry about it if it's under 100,000. In fact, you don't have to worry about FERPTA if it's under 300. But the escrow company does the state and federal together, so the state exemption is 100. But the federal, you don't have to worry about FERPTA, technically under 300. How about before I open up to general questions, which I'll be glad to do, stay as long as you want me to, let me just finish up with what I wanted to cover. Finishing up forms. So that takes care of, I talked about the things that change. The only mandatory new forms are the tenant, flood hazard, and the bed bug form. And I talked about the 2 advisories that came out in July. So what's going to happen in December? What's the form changes in December? I already mentioned the agency. I already mentioned paragraph 2 of the purchase contract. Are there any new forms coming out in December? The answer is 3, none of which are mandatory. The first one is called the pre-occupancy storage agreement. I call it the put your crap in the garage before you move in form. First of all, is that a good idea? No, it's not a good idea for the buyer to put some of their stuff in the seller's garage before they move in. So you try to discourage your clients from doing this, but sometimes they want to do it anyway. No, I don't care what you say. The seller's okay with it, so I'm going to move some of my stuff into the garage before it closes. So you're going to say, this is a dumb idea, but if you're going to insist on doing it, you might want to use this form. Because this form deals with things like, you know, who's responsible if something happens to that property? Or what if the escrow doesn't close? Then what happens? You know, all these things that you're anticipating, which would make it a bad idea to even do it. If they're going to do it anyway, we have a form that at least makes the situation better than it would be if they didn't have the form. So we got the POSA, Pre-Occupancy Storage Addendum. What if the buyer themselves wants to move in before close of escrow? Really dumb idea. Even dumber, a lot dumber than moving their stuff in. In addition to the obvious reasons, did you know that under California law, if you're in escrow to buy a house and you move in before it closes, and in between the time you move in and closing, there's some type of natural disaster like a fire or a flood or an earthquake, buyer, by moving in early, you assumed all the risk. So you move in on Monday, it's closing on Friday, on Wednesday there's an earthquake. Buyer number one, you still have to buy the house. And number two, seller doesn't have to fix it either. Do you see how dumb it would be to move into a house before it closes? The only way it's not dumb is if you actually sign a rental agreement. Because if you're a tenant, you don't assume the risk of loss. So either don't let your buyers move in early, or if they do, make sure they sign an agreement where they are moving in as a tenant. Because if you move in early not as a tenant, you are taking a horrible risk there as a buyer. So don't do it. Now, moving your stuff into the property, you're taking a risk, but not a big of a risk. I mean, you're risking your property, which is still probably not a good idea. But nevertheless, it's something, at least we have a form to, you know, we actually have a form for the buyer moving in early too. It's called the Buyer Early Occupancy Addendum. If you ever look at this form, it says on this form, if you're using this form, you're a bad person. You shouldn't be doing it. It doesn't say that. It says, by using this form, you're going against my advice. Anyway, are there any other forms? I said there are 3 forms coming out in December. That's one. The other 2 are completely non-binding, non-mandatory questionnaires. So I just got through telling you a buyer who buys a condo typically doesn't read the governing documents before they move in. So there's a new form that came out in July that advises them to read them and tell them what to look for. But there's another new form along these same lines coming out in December, which is called the Seller's, I'm sorry I don't have it with me, the exact name. It's something like Seller's Common Interest Questionnaire. So it's actually going to, once again, solving the same problem. The seller's going to answer some questions like, is there a no pet policy? Is there a no smoking policy? Is there a no renting out your units policy? Stuff that's in the governing documents, but the buyer's probably not going to read it anyway. Even once you give them the advisory, they're probably not going to read it. One more way to solve bad blood by getting information into the buyer's hands, because obviously there's many lawsuits and buyers moving into condos and not knowing what's going on. So once again, you don't have to use this form. And the last new form is a questionnaire on mobile homes. If you sell, it's the Seller Mobile Home Questionnaire. Once again, if you buy into a mobile home park, you're supposed to read the mobile home park rules. But the buyers don't read them. They move into the mobile home and then they get surprised and they're unhappy. So this is a way for the seller to communicate that information to them. These are all forms to avoid problems. They're not mandatory. So the only mandatory things I've told you are tenant, flood zone, bed bug, and make sure you're using the new agency form by the end of the year, and obviously using the new purchase contract. And obviously use zip forms, they're automatically updated anyway. Okay? And that is all you need to know on forms. That is pretty much all you need to know on laws. Give me 5 more minutes and wrap this up. I got more good news for you. Good news is always good. And that is, remember I told you last year about the new tax law that cut the corporate tax rate? But CAR was against it. Remember why CAR was against it? Because it puts a cap on the deductibility of property taxes at $10,000. I mean, in other words, this year you can deduct all your property taxes and all your state income tax. Doesn't matter how high your property taxes are, doesn't matter how much state income tax you paid. However much you pay, you can deduct it all. Next year, you can only deduct the first $10,000, which you still might not be paying more than $10,000, which it doesn't affect you, but it affects people in higher end, you know, with more expensive properties, et cetera. There. So that's why CAR opposed it. You know what's interesting though? It's $10,000 if you're single or married. So if your property taxes are over $10,000, get divorced. You can still live with your ex-spouse, but you each file separately. You can each get $10,000 write-off. All right. Get divorced. Okay. And the other bad thing, of course, is there's a cap of $750,000 of mortgage interest. So if you borrow more than $750,000 on your primary, if it's income property, you can deduct it all. But if it's more, you're borrowing, the cap has gone from $1 million to $750,000 on how much mortgage interest you can deduct on a loan secured by your primary residence. And the third bad thing was the fact that if you're borrowing against your home equity, you can only deduct the interest on that if you use the money to improve that property. So if you pull money out of one house to buy a car or fix up another house, you'll no longer be able to deduct that interest. Okay, so those are the bad things. The good things, though, I'm getting to a happy ending here. The good things are, number one, all of us in this room, our tax rate is going to be lower because the rates have come down. Number two, who in this room has dependent children? I know all your children depend on you forever. I know that, but legally dependent. Did you know they're worth more money to you now? The tax credit's gone from $1,000 to $2,000. Your kids are worth an extra $1,000 on your taxes. Yay! Well, should the rest of you go out and have more kids? No, they're going to cost you more than $2,000 a year, I guarantee. Okay. But there's a third very important good thing that the IRS has recently clarified that they really meant it, it's really true, and that is every realtor in this room has a new write-off next year. Well, not every realtor. If you're too successful, you don't get this. But here's the deal. And they clarify that. Here's what you do. First, figure out your taxes under the old rules. You know, your income, do all your deductions. If your net taxable income, the money you pay your tax on, is less than $157,500, go back and recalculate your taxes. And this time, when you figure out your Schedule C, your net business income, take off 20%. Let's say, for example, your commission income for the year is $100,000 gross, and after paying all your business expenses, it's $70,000. Take that 70 and deduct 14,000. Now you're down to 56. Then do your other deductions. Then do your standard deduction or your other itemized deduction. In other words, you don't have to itemize to get this. This is on your Schedule C. Your Schedule C, whatever that bottom line is, you're going to take off 20%. All the way up to $157,500. So if you're making $150,000, you're going to take off $30,000 deduction. That's really good. Well, what if I make more than $157,500? Well, it phases out up to $207,500. So if you make like $180,000, you're going to deduct 10%. If you make $200,000, you're going to deduct like 3%. If I make more than $207,500, I don't get any of this. None of it. You don't get 20% off the first $157,500. You get it only on $157,500. Okay, so let's say I make $100,000 and I'm married to someone who also makes $100,000. Do I lose it? You don't. You calculate your $157,000 separately. Okay, but you're still cut off at $157,000. But what if I make $250,000 and I'm single? Well, if you're married to another independent contractor, it goes all the way up to $400,000 17. So if you're single, get married. To some loser. Because if you marry someone who makes a lot of money, you're going to go over the threshold and lose it all. Okay, it's okay to marry someone who's successful as a W-2 employee, but don't marry another successful independent contractor, because your guy's combined income is going to go over the 315, whereas if you're married to a W-2, you can do yours separately. Okay? So part of the tax law is saying get divorced. Part of the tax law is saying marry some loser independent contractor. It depends on your situation, what you should do. But the good news they clarified is that if you're married to a W-2, you still get it. His or her combined income doesn't take you over the threshold. But if they're an independent contractor, you might have an issue. I'm not an accountant, so there may be other ways to do this, like filing separately and not having to get divorced, or I don't know what you do. Yeah, in other words, what if you're already married to a successful independent contractor? Get divorced. You can still live together. It's okay. Okay. Anyway, so you're getting all sorts of direction from the tax code here to remember. Okay. All right. Let's see if there's anything else you really need to know. Okay, a couple more good news. Good news, bad news. There's been a significant change to your code of ethics, and that is regarding the duty to present offers. You know there's a legal obligation and an ethical obligation to present all offers. But some of you may come across a situation where you don't think your offer got presented. You submit an offer, no response, and then it's pending all of a sudden. It's in escrow, and then it closes for less money than your buyer even offered. You say, how the heck did that happen? Then you notice that the listing agent and the selling agent are the same. Now you know exactly how that happens. Your offer got sabotaged, so the greedy listing agent could double end the deal. Hopefully this doesn't happen often. Hopefully maybe it never happened to you, but it does happen. So there's a place on the bottom of the purchase contract, right? Where there's a little place for the listing agent is supposed to put down, document when they presented your offer. Unfortunately, up until now, there's been no requirement to fill that out. So a lot of times you'll submit an offer and the listing agent doesn't come back to you. In other words, it's supposed to come back to you even if the offer is not accepted. The Code of Ethics has now changed. Listen very carefully. It says, if you ask the listing agent, they must document that they presented your offer. What does this mean? That means they have to put in writing, I presented your offer at 6 p.m. on October 25th. Well, of course you're saying, well, they could just lie. Well, of course they could lie. But the fact that they put it in writing means if you figure out that they lied, they are guilty of fraud. And you can get severe damages. You can get damages equal to, they can have to pay damages equal to the difference in the price of the offer they didn't present and the offer that was accepted. Not to mention they can get fined at the Board of Realtors. The Professional Standards Committee would have the right to just fine them. So this is going to be a serious violation. I mean, the point is, up until now, the listing agent could get away with not documenting in writing that they presented your offer. Starting January 1st, they have to document in writing that they presented your offer. I mean, like I said, the bad people who I know are not the people in this room. The bad people may still not present offers and lie about it. But now if you catch them, how are you going to catch them? Well, call up the seller after close and say, does this offer actually presented at October 25th at 6 o'clock? No, I never got that offer. Boom. That's a problem. Yes?
Yeah, can we still request, and I don't know if this is local or state issue, as the selling agent, the buyer's agent, to present yourself on behalf of the buyers correctly to yourself?
He's correct. Not only is the Code of Ethics I was just talking about, your current MLS rules, this is in the standard MLS rules, which means your MLS, every MLS says, under the MLS rules, you have the right to say to the seller's agent, I want to present my offer in person to the seller. And you have the right to do that unless the seller in writing says they don't want that. So if you say to the listing agent, when can I present my offer to your seller? And they'll say, oh, he lives in Iowa, so I'm going to do it over the phone. You say, okay, I'll be on the phone call, no problem. We can do Skype, we can do whatever you want, but I want to be there when the offer is presented. And if they say, no, I'll take care of that for you, you have the right to say, okay, please, for my client's benefit, put that in writing, signed by your seller. So that's a powerful tool you already have to prevent listing agents from doing funny things. So this new change to the Code of Ethics is just one more change. And what the Forms Committee hasn't decided yet, they may just put something right on the bottom of the purchase contract that says, buyer's agent hereby requests that seller document the offer presentation. Because remember what I said? The Code of Ethics, the new rule says, upon the buyer's agent's request, the seller's agent has to document the presentation. So what if you forget to request? So I just don't know yet whether between now and then they may put something on the purchase offer that makes it an automatic request. I don't know yet. Okay?
Does that apply to REOs as well?
Absolutely. Everything I said applies to REOs. Yeah, absolutely. So I don't know if that was a happy note or a sad note to end on. Yes, sir.
So, did you say that you're going to change the way that's written at the bottom?
It's not.
Initial date, time, you can just scribble on there. You don't know right now.
Well, I think it's got to be legible. I think if it's not legible, they haven't done it. My point is, that is no longer optional. The seller's agent is now required to fill that in. They are required to by the Code of Ethics if the buyer's agent requests it.
Doesn't that say the agent or the seller?
They're two different things. They're two different things. On the bottom of the purchase contract, there's a place for the seller to reject the offer, and there's a place for the seller's agent to say they presented it. The seller rejection part, that's not required. The seller doesn't have to do that. There's no law requiring sellers to reject offers. But there is a requirement now under the Code of Ethics for the listing agent to document that they actually presented it. Is there a hand over there? Last thing I forgot to say one thing that's semi-depressing, but we got to know about it. Dual agency, remember last year I told you that the big case of the Supreme Court was that if one agent in a company has the seller and one agent has the buyer, it's not just the company that's a dual agent, but both of the individual salespeople are dual agents. Remember that? So if you work for a big company, you have got the seller, somebody agent in the office has the buyer, that's your buyer too, for liability purposes. Unfortunately, what that means is you have to pretend that you're the only agent in the deal. You got to treat that buyer as if they didn't have their own agent, because you are their agent. Remember, when you're someone's agent, I mean, if you're the listing agent and the buyer is represented by a different company, what is your duty to that buyer? Simply disclose material facts and be honest. But if the buyer is your own buyer, what is your duty to that buyer? Not just be honest and disclose material facts, you also have to provide advice and counsel. So if you have the seller and the buyer is represented by another agent in your office, you still have to advise that buyer. You're a dual agent, but you all raised your hand early. You know how to be a dual agent. Plus, I got through telling you, the good news is it's a little bit easier to be a dual agent right now because it's been clarified that if one of your clients tells you something in confidence, you don't have to tell the other one. So it's a little bit easier to be a dual agent, but you're just gonna be a dual agent more often than you used to because of that Supreme Court case. Now, what if you have the seller and the other agent in your company has the buyer and she's your best friend, you've known her for 30 years, she's the best realtor you know. You're probably pretty comfortable she's going to take care of the buyer. And you're going to take care of the seller, you're going to work it out. You're not really worried. But what if you're the seller's agent and the buyer's agent is brand new in your office? He just got his license yesterday. He got out of prison a week ago. You know, so he's, you know what you're going to do? You're going to take over the deal because that is your buyer. And that buyer needs to be treated like, you can't say, well, I wasn't his agent, you know, I wasn't. No, you were the agent of the buyer, and you have to help that buyer as if you were the only agent in the deal, because of course, unfortunately, under that Hariki case, you are a dual agent as if you were the only agent in the deal.
What if the other agent is saying back off?
They can't. That's a good question. That's their first reaction, going to be back off, don't talk to my client. And you're going to say, that is just as much my client as your client. And by the way, my client is just as much your client. Dual agency is by, every individual in the office is a dual agent, just as if you were the only agent. You got to remember that. And unfortunately, as we predicted, in the last year since that case happened, there have been a lot of lawsuits where now buyers sue both agents rather than just their own agent. Buyers have an extra person to sue. Isn't that great? Well, don't sellers have an extra person to sue too? Yeah, they do, but sellers never sue. Do you know 99 out of 100 lawsuits against a realtor are from the buyer? Sellers don't sue very often. Buyers will sue you at the drop of a hat. So on that happy note, any more questions? Yes, sir.
Two questions. On the pet issue, what if the complex is marketed and all the tenants occupying the pet-free complex?
You say it was advertised as a pet-free complex?
The prior tenants rented without...
Everyone agrees there's no pets. Are you saying and then they have a service animal or a pet?
Well, what happens? Can the landlord continue to restrict?
Pets, yes. Just not service animals or companion animals. That's the problem. They can continue... Well, what about smoking? Here's one. What about the landlord allows smoking? Allows marijuana smoking. So the tenant says, I'm moving there. That's the place I want to live. I can smoke. So then they move in, they're smoking away. Then a new tenant moves in next door. And he starts complaining. Hey, the neighbors smoke. I'm smelling their smoke. Landlord can say to the new tenant, I told you this was a smoking place. You were accepting the risk when you moved in that you're going to smell smoke. Sounds good. But then that second tenant goes to the doctor. Doctor says, you are suffering from a respiratory illness caused by smoking, by secondhand smoke. Once you get a doctor involved and once it's medical, you go back to the landlord with that doctor's note. Now the landlord is in a different situation. Now she's got to say to the first guy who smokes, sorry, you got to either stop smoking or make sure that smoke doesn't get to your neighbor. And then he says, the whole reason I moved here is because you told me I could smoke. I know, but that was before you were making another tenant actually ill, sick by your smoking. So in some case you have to make them stop smoking even though they could. Remember, by the way, landlords can prohibit tobacco, and landlords can obviously prohibit marijuana in any kind, even to someone with a medical marijuana card. So the only legal thing about marijuana is you can grow 6 plants in your house if you own your own house. And it's not part of an HOA. An HOA could say no marijuana. Landlords can say no marijuana. But if you got your own house, you can grow 6 plants. How about if you're driving around in your car, can you take your plants with you? No. Can I take any marijuana with me if I'm driving around in California now? Yes. An ounce, if you're over 21. It's 6 plants in the house. What if, is it 6 plants per person or 6 plants per house? Per house, sorry. Can I grow the plants in the backyard? No, you can't if they're visible from the public, to the public. If it's not visible to the public, you can grow them in the backyard. Can I grow more than 6? Only if you get a license. Does Bakersfield even issue these licenses? Most cities don't.
No.
Has anyone ever been to Ukiah? My impression when I was there is everyone was high. I mean, the waitress, everyone else in the restaurants. I just thought I'd throw that in there. Okay, don't go to Ukiah. Yes?
On your scenario of assumption of the risk by buyer.
Yes. Yes.
Would them putting their possession.
Putting their stuff in there. Right.
Is that?
That doesn't, good question. He was thinking along the lines I said, I said very bad for buyer to move in early, not as bad to put their stuff in early. He's thinking, well, can it be argued by putting their stuff in there that they're quote unquote moving in early, right? As long as they're not sleeping there, the fact that they move stuff in, they don't assume the risk of loss that I just mentioned. They just move, assuming the risk of loss on their stuff, probably, okay? Any more good questions?
Bed bugs.
Yes.
Tenant pays or landlord?
To get rid of the bed bugs? Yeah. So the law is you got to give them the form. And the form basically says to the tenant, if you have bed bugs, tell the landlord, and the landlord has to get rid of them and cannot retaliate. In other words, they can't evict you because you have got bed bugs. But his question is, well, can I at least make the tenant pay for getting rid of them? And yes, you can. Of course, the tenant's going to say, how do you know I brought them in? Because it wasn't furnished. And you brought in the furniture. Well, how do you know they weren't in the carpet? There's no carpet. How do you know they didn't come through the wall? You know what, I hate to tell you this, landlords, it's almost like to be safe, every time you get a new tenant, you do a bed bug inspection before they move in, you get a pest control person to say there are no bed bugs here. Then that creates a very strong presumption if they move in and there are bed bugs, they brought them in and they have to pay. Sorry about that. And remember, bed bugs form even applies to short-term seller carryback, vacation rental, Airbnb. Crazy. How many legs does a bed bug have? Too many? Anyone else? 6 is right. How do I know? Because it's on the bed bug form. Yes? Yes?
They had bed bugs and they eradicated them. So
the tenant or the...
They need to get a document saying...
Wait, you're saying you own a home?
No, it's a...
You're listing a home.
Yeah.
So it's not a rental situation. Well, it's between the buyer and seller. This law doesn't cover that. This,
she had bed bugs. She got rid
previous owner got rid of the bed bugs.
So they need like a clear termite or a clear bed bug.
Oh, I see what you're saying. I don't think this... We haven't gotten to the point yet where the seller has to tell the buyer that I used to have bed bugs. You don't need a bed bug clearance. Lenders don't require a bed bug clearance. At least on sales, I would say don't worry about bed bugs. Just on rentals. Yes, sir.
So on your scenario with the tenant that had the respiratory issues, so what if the other tenant's smoking, but it's marijuana and he has...
Yeah, that's a very good question. The answer is too bad. Even if you have a medical prescription, landlords do not have to allow medical marijuana, nor do HOAs. The law specifically says that medical marijuana, you don't have to, landlords do not have to allow it. Even if they don't have a tenant who's getting sick, just the landlord says, I don't want it. That's enough. Landlords...
But in that scenario, the landlord did allow the smoking of it.
But they can change. Wait, landlord did allow...
Yeah, so...
Oh yeah, in my scenario. But they can change their... You can always change the rules.
But do they have to if the other tenant has a prescription?
I see what you're saying. Now I see what you're saying. Tenant number 1 has medical marijuana card, smokes medical marijuana. New tenant goes to the doctor and says you're getting sick from the secondhand marijuana smoke. Landlord still has to go to the first tenant and make them stop.
You said...
Yeah.
You said the longest who lived there.
That's if you can't accommodate both. You're right, it's a good point. The first thing a landlord would try to do in this situation is say to the smoker, I got another unit down here, could you move down there so you aren't bothering this one? You try to reasonably accommodate both tenants suffering from some disability. But sometimes you'll be in a situation where 2 disabilities conflict with each other. In that case, the first one there's rights sort of trump the next person. Okay? Yeah?
Well, in this example, how is that any different than therapy?
Just because they're different rules. It's only different because the law is different. I don't know why the law is different, but the law is different. Yeah. There's special rules for marijuana and smoking. Some of you are getting ready to leave here. I can tell you're saying, all right, already, no more questions. I'm ready to go. Okay, I'm done. Thank you. Goodbye.